Hi, I'm Christy Griego, and this is my presentation for Professor Greene's Business Law and Ethics class. The topic I chose to speak about is non-compete agreements. So what is a non-compete agreement? Well, it's also known as a restrictive covenant, and it's a condition of employment that if an employee is no longer employed by the employer, the now ex-employee is prohibited from working for or owning a competitive or similar business, contacting any customers and employees of the employer. Now, this is also known as a non-solicitation, which is sort of a lesser restrictive than a non-compete, but a non-compete basically is a complete prohibition from working, so it also includes contacting customers. So where do you find a non-compete agreement? Well, it could be a standalone agreement, or it could be a joint with a non-solicitation and confidentiality agreement. It could be a clause in an employment contract, could be language in an offer letter, or it could be part of a new hire packet. So look before you sign all that paperwork. Employment policy or handbook with a signed acknowledgement page, and in a separation agreement. And some of these can be in electronic format with your electronic signature. So are they legal? Well, it depends on the state. Each state has different laws, but they are generally enforceable in most states. They're required to protect the legitimate business interest of a company. Some states enforce them by statute, but many others by common law. It's considered a contract, so it follows laws applicable to contracts, which are easier to enforce than torts. Most states have standards, such as limited by time and geographic area. And some states have exemptions. For example, they're not applicable to certain professions like those in broadcasting. States vary on whether continued employment or at-will employment is considered adequate consideration. Most states will enforce an agreement, even if the employee has been terminated without cause. There's only a few states that generally prohibit them, and it's California, North Dakota, Oklahoma, and Idaho for key employees only and limited to 18 months. So they're not totally prohibited, but they're generally prohibited. So what does New Mexico say about non-compete laws? Well, there's not a statute for them generally, but the Supreme Court has held that they're enforceable. But they need to be reasonably limited in time, about 2 years, and reasonably limited in geographic scope, about 50-mile radius, and supported by adequate consideration. Continued employment is not adequate consideration, but new employment is. There is an exception in the New Mexico law by statute, and that's because our state suffers from a shortage of healthcare providers. So restrictive covenants are not enforceable on doctors, dentists, midwives, and nurse practitioners. The exception to the exception is it doesn't apply to healthcare providers who have an ownership interest in or a director of the practice. So if a doctor were to sell his practice, he can't go across the street and open up a new practice and then take all his patients back. So now let's look at the employee versus employer perspective. There's two sides to every story. From the employer's perspective, it's a way to reduce the risk of economic harm. Employers need to protect their confidential information, trade secrets, and proprietary information. Non-competes offer employers a powerful means of protecting their most valuable assets, their client relationships, and their employees. As we learned from economics class, employees and the HR is one of the 4 factors that drive an economy. And what gives teeth to non-compete agreements is the inevitable disclosure doctrine. And that allows courts to enter a TRO because a former employee will inevitably disclose the former employer's trade secrets in the performance of his or her new job. And it's fundamental in trade secrets law that a trade secret, once lost, is forever lost. But from the employee side, employees feel that they're giving up some of their personal rights. They're one-sided, as a non-compete favors the employer over the employee and does not protect the interest of the employee. And since the average employment nowadays only lasts about 4.5 years, non-competes severely limit an employee's ability to find future employment and earn a living. It limits an employees to utilize the various pieces of information or context gained during their employment, i.e., their advantage of their prior work experience. But there are ethical considerations for both sides. For the employer, it's the big corporation versus an individual, the David versus Goliath scenario. Employers can take advantage of employees. And especially under these economic times when recession left employees with no choice but to accept the employer's terms, and more employers are starting to implement non-competes. And they're pretty much unnecessary for lower wage earners that don't have access to proprietary information. And it's unfair to place restrictions on discharged employees. If the employer no longer wants them, why not let somebody else have them? And it's unfair to restrict contacts that the employee brought to the employer. And again, it should be limited to the employer's legitimate business interest. It places restrictions on trade. It affects interstate commerce and stifles competition and free trade, the very nature of our capitalistic society. It's not regulated by the federal government, though, even though it does affect interstate commerce. And sometimes it's considered against public interest. It can have a detrimental effect on the health and well-being by restricting consumer choice. It stifles innovation by reducing the diffusion of skills and ideas between companies within a region. Are they really necessary on contracts that are put out for public bid, such as RFP? The state puts out bids for painting contracts and landscaping contracts. And it's all fair game to anybody. So why should a restrictive covenant limit that type of service? So it seems like the employer wants to have its cake and eat it too. It wants to impose post-employment obligations by contract, but state that the employee is at will, meaning that they can fire them for any or no reason. Now, what about the unclean hands? When an employer commits fraud, harassment, engages in unethical behavior, and doesn't treat their employees and offers poor customer service, it's not fair to restrict the employee to that particular employer. And then if there's a material change in condition of employment. What if the employer severely reduces the employee's wage or responsibilities? It's not fair to obligate that employee to that restrictive covenant. And consideration is another factor. Shouldn't the amount paid be equal to the restrictive period? If you're not going to allow somebody to work for 2 years, shouldn't you pay them 2 years worth of salary? And other laws, such as the Uniform Deceptive Trade Practices Act, offers protection, kind of making them unnecessary. But there's ethical considerations for employees too. Employees can intentionally take advantage of the employer, some beginning setting up their own business while working for the employer. We have 2 such litigation now at the firm I work for where that was the case. They were using the employer's computer and company equipment to start setting up their own business. And the employers also take advantage by using their contacts and employers' equipment and vendors to get special pricing for their own business. And some even steal trade secrets, such as the example I gave in the Uber self-driving car during one of my discussions, where a top exec from a Google-owned company downloaded all the trade secrets for the self-driving car and then started to work for Uber. Needless to say, the Google company sued and Uber is no longer looking into self-driving cars. And we've had it where employees delete information from their company's computer, just wipe it all clean. And then, before they did that, they transferred it to their personal email or their personal computer. And word to the wise, IT professionals can go back and look to see what you downloaded and what you transferred when and where. So it's no secret. And then some start bad-mouthing and defaming the employer to the customer, saying, these guys aren't going to last very long. I'm going out on my own. I can help you out. So it's not just employers behaving badly, it's employees too. But are they beneficial and really necessary? Here are some couple of charts I found from the Obama White House blog page. And it says nearly 1/6 of the workers earning less than $40,000 a year are bound by non-competes. I can understand non-competes for high top executive positions with high access to trade secrets, but those with little to no college education, earning less than $40,000, that's really putting a stretch on things. And it reduces wages. Workers in states with have lower levels of average wages in states that, the most of the states that enforce non-competes. So I have some recommendations for both employees and employers. So what can an employer do? Well, do your due diligence when you're hiring employees. Do your background checks. Do reference checks. The resume has somebody hopping from job to job year after year. It's more than likely not going to stay with you very long either, and then you're going to have to turn around and spend money to enforce a non-compete. Keep your customers happy. Don't let one sales rep be the only contact for the client. If you're the owner or a top manager, you need to make sure the customers know who you are, not just your one sales rep. And quickly address any customer concerns. Also, keep your employees happy. If you treat them well and pay them well and offer them incentive and benefits, they're likely not to job hop. And what can employees do? Negotiate. Request more consideration. Request a severance package if you're terminated, even as part of the hiring process, not just after you're terminated. Try to reduce the time and geographical scope of the non-compete. Limit it to existing customers and clients only. And you can also reject or refuse to sign. Of course, you probably won't get the job, but you've got to take into consideration what you're giving up to take that job. And get your own attorney. Have your attorney review the contract to ensure you understand what your obligations are and the consequences of those obligations. Or negotiate a better deal for you. Make the attorney be the bad guy. That's what they're there for. And not only can employers perform a background check on employees, but it can be reversed. You can perform a background check on the company. You can look to see, has it sued its other employees? And I've listed here the New Mexico State Judiciary case lookup at nmcourts.gov, and you can see if your employer has been involved in any lawsuits in New Mexico. And if all else comes to fail, maybe you should be prepared to move, commute a little further, or work in another field altogether. So I'd like to acknowledge some of my references. And this first reference I really want to point out because those of you who are considering working in states other than New Mexico, the first reference really gives a good chart of all the states and a brief overview of what kind of non-compete laws they enforce. And here are the statutes and cases I referenced in my presentation. And thank you for watching. I hope you thought it was informative.